This is the R in Real Estate.
Hi, thank you again for tuning in. This is the R in Real Estate. Thank you for joining our podcast. I am Asia Williams, broker CEO of Asia Realty by Molan Group. And again, we are with the R in Real Estate. Each and every week we have a segment. This week, our R is, what's our R this week?
Rhea.
Relationship. Yes, right. Real. So
Keeping
yes,
it real with Rhea.
absolutely.
Yeah.
I have the amazing opportunity of having my partner, friend, amazing firm, and the art in real estate for this week is Rhea, attorney Rhea.
Thank you. Asia.
Thank you.
Appreciate it. So I'm just really excited to be here. I'm always excited to be with Asia and her team and her audience. Asia is a friend to so many people. She's a partner to so many people, and I really admire her energy, her spirit, and I just think that she just goes beyond and just exceeds everybody's expectations always, and really, really works hard to try to make every deal close. So I really like that about Asia, and I'm always referring Asia to.
Thank you. Same. But yeah, definitely, because with this podcast, we definitely want to be able to inform, build our communities, be able to give great information, great insight. But definitely, you feel free to contact us. You can call in, be able to join the show. We'll give details on that as well. And I would say amazing thing is we both from Atlanta.
That's right. ATL.
Yes, I was born and raised Atlanta. I grew up on Cleveland Avenue, the South Side.
Yeah, so I grew up in a couple different places, but I claim the South Side too.
Okay.
So I'm a Grady baby.
Yes,
and,
me too.
I started at in University Homes.
Okay.
But my mom eventually, she graduated to home ownership, and so she bought a home off of Metropolitan Parkway.
Awesome.
So that's where I kind of, consider my roots to be.
Good. See, you look both Atlanta natives, right? And we crossed paths and was able to work together. So definitely we see some changes that has taken place, a lot of growth throughout our city, as well as I want to be able to be impactful, build our community as we continue to build businesses, home ownership. I strive for our residential, our community areas as well. So yeah, tell us a little bit about yourself, your firm. We do have the pleasure to you all. This is our closing firm. Will, probate, just
estate planning.
Everything. Yeah, estate planning. So yeah, tell us about your firm, your insight with real estate.
Awesome. Okay. Well, my husband and I are in practice together. We've been in practice together since 2007. We are pretty much community-based lawyers in the sense that we work directly in the community to help educate people, because I think education is the key.
Yes.
So when I meet clients and people come in and consult with me, whether they actually move forward with a legal case, whether they decide to retain or not, I always try to work with people to provide a certain level of education, because I think that litigation in a lot of cases can be avoided if people understand before they get involved, and especially with the real estate. That is one of the biggest things I see, is that people come in and they have questions and they're looking to make money. All right. So everybody's looking to make money, but they are so quick to get in bed and get involved with people that they really have not vetted and they haven't done their due diligence. And so that's one of the things that we talk to people about, is making sure that as they step into this pool, that they understand that investing and working and partnering and joint ventures and all of that stuff, and home buying even, is an investment that you're making. And you really do have to consider so many details. And we don't try to discourage people. We tell them to do it. That's what they want to do, but they need to be informed before they start the process. So that's what we are big on, is education.
Yes, absolutely. And that's what I love, because it's not like, of course, we make money through the process and then they doing the transaction as well. However, but it's just the impact of being able to know, because a lot of times I think people don't know and tend to make mistakes from what they don't know, instead of, asking, getting the right consultation. What would you say is one of your biggest challenges with real estate deals?
I think probably the biggest challenge is it just depends on what the goal is for people.
Okay.
When people are looking to buy a home, a lot of times, I hate to say, they do rely on their real estate agent quite a bit.
Mm-hmm.
And they don't read the documents. So they don't really understand what they're getting involved in. They don't understand, what due diligence is really about.
Right.
And what they should be doing during that due diligence period. And then once they sign on the dotted line, once they extend earnest money, or on the seller side, once they sign on the dotted line, that they are bound to the agreement.
Contract, right?
Yeah. So a lot of times we see a lot of issues that come back, and people haven't really read what's in it. Mm-hmm. And I think that they are expecting that their agents are going to tell them the details, and some agents are good about doing that,
right?
But some are not. And so even when it comes to like homeowners associations, that's a big one,
right?
So it's just reading and reviewing. I have had clients who have had real estate agents that still felt like they needed legal counsel. Mm-hmm. And so they'll come in with their documents and want us to review everything, even though they have an agent. And so sometimes I'm kind of like, okay, did your agent talk to you about these things? I kind of lean toward that. But at a certain point, if people need the information, we are available to provide it, because we really hate to see people get in bed with something that they don't know what they're doing.
And I would say too, any of you agents, realtors that's out here, definitely take the time, and I do pride myself with our agents here at our brokerage. You have to definitely communicate. And I know a lot of times, people are busy doing things, but yeah, rely on your team, because I do have a team as well. However, with the clients, like when they're getting documents, and I know instead of think you got to rush it, when they get documents, I say, hey, like, for example, this morning, I said, listen, we sent you over some. Take the time to read over it. You may want to jot down some notes, so you want to ask me. So, and I will conference with you at 2:00 so we can go over it, right? Mm-hmm. Even though we know it's a amendment to address concerns, even though we know that we want to sign it and get it over timely, but I want to be able to give them the documents ahead of time. Mm-hmm. That way they can review it. Even with contracts, when you put in offers, look at it ahead of time and be able to read. And agents, take your time too to read your contracts, your documents, and know, because I think a lot of times some of the failure too with the agents, they looking at, like when I'm doing compliance, of course, you want to make sure everything, the signatures, your dates, everything, all the promises are on there, but you also want to know your contract. A lot of them don't know the contract. So you want to be able to take time and read, know your contract. That way you're going to be able to take the time, be able to better help your clients. But you want your clients to have the opportunity to read over documents, the contracts, and then conference with them to go over any questions or concerns. But of course, some things are outside the realm where you need legal counsel. Reach out to your attorneys, but for the most part, know your contracts, know what your clients are in need of to sign, and know what you're responsible for too.
Yes. And I definitely think it's important to do your due diligence when you are choosing an agent, because they are your first point of contact. And sometimes the agent is the one that reaches out to us to say, hey, can you explain this to my client? We have agents that reach out to us for legal advice because they don't understand some of the documents that they're reviewing, and maybe they don't have that tool in their toolbox, and so they ask us for information. So I have several agents that reach out to me via email around the clock, and they'll say, hey, I got a situation that's coming up, and can you look at this, can you give me some advice? And so for the most part, I'm able to give them some structured, good legal advice. But at the end of the day, it really comes down to you when you sign off on the contract. And I'll give you an example. I had a seller once, and she had basically signed off on a contract, and in the contract it said that she would leave the appliances, like the refrigerator. She was going to leave it. And then, when she moved out, she took the refrigerator, and she didn't realize that that's something she had agreed to. And she got sued by the buyer a couple of months later for that refrigerator. And when I look back at the documents, she really just had no idea that was in there. She had no intention of giving her refrigerator away. And so at that point, she had to pay the buyer the difference. So basically the cost of her, because at this point the buyer has bought a new refrigerator. Okay. But they're still coming after her because it's a cost and expense they didn't anticipate. So she ended up having to pay them, several thousands of dollars for their refrigerator. But, at least she was able to avoid a full blown lawsuit after reviewing the documents. And had she done it beforehand, she would have just
and viewed it because, and then this too, what I have our agent doing is specifying because appliances, right? When you say appliances, just like when you're doing new construction, appliances is really your refrigerator. I'm sorry, not refrigerator, the stove, the dishwasher, the range oven, if there's one. And then a lot of times they don't include the refrigerator, right? I'm looking at new construction. Even when we run these contracts, what I have our agents are doing, like these special steals or whatever the promises are, I put in writing to say all kitchen appliances, including the refrigerator, because without it, people think refrigerator, because it isn't. It doesn't have to be there like for inspections or appraisals because they're looking at dishwasher and stove connection, of course. But definitely that needs to be. Then if it's in there, that's what you gotta give. Some people like, I was gonna give all the appliances, but not my refrigerator. But it gotta be, make sure everything is in writing to be in compliance. But if you are, always put including the refrigerator.
And I mean, you brought up a really good point. New builds, I see a lot of problems with that. So we have a lot of people that come to us and they are ready to sue the builder, either or the builder is holding their feet to the fire and won't release earnest money. And a lot of times the pricing that they initially agreed to increases. And there's something written in the initial contract that allows for some increases with cost, and they don't realize it, and they're just, feeling overwhelmed. I've had people to move in, and little things were happening, like little cracks or little leaks and this and that, and they wanted the builder to fix it. And so the builder has a process by which they fix things, but it may not be to your level of satisfaction. So it's really about reading those details and understanding that when you sign up with a builder, they have drafted the agreements with their attorneys, and they have really made sure that they've got all kinds of provisions and they're covered.
And you gotta read those because back when, what was that? After COVID, with all the bills, right? With all the new bills, they would have, because we had delay on material, building material, and then they had this clause in there, like if, let's say, cabinets, they were used to, for the last 5-6 years, doing cabinets at a cost. But then when you had things on back order for the building and all of that, the cost went up. So they was calling clients back in to re-sign something saying, these are the cabinets I picked out, but they no longer available. That's why now you see a lot of builders, they sell once they built instead of starting at the lot. But it's like, that was challenging. Again, that goes with making sure you reading over the contract, because we have the GAR forms, right? That's already been drafted. Those are our Georgia Association of Realtor forms. But we have those forms, but if you with the builder, they have their forms. That's why it's up to the agents doing your due diligence. You gotta read through before your client even signs on that new bill to know what's on there, because a lot of times I found some things was in there that I might have closed with a bill, and then 6 months later I got another client, those things are taken out, or so revised again. So you got to definitely pay attention to that.
Because I mean, you want a certain level when you're moving into this new build, and all of a sudden the chandelier or this fixture that you wanted, they don't have that available, and now you have a lower grade chandelier, but the price hasn't changed. So, it's a lot of issues that come along with the new build. And I would just say, first out of the gate, really look at the homes that they've already built, and look and see what the quality is before you get in bed with a builder. Look at their reputation. Look and see if they have reviews, if they have complaints. Because once you get in with them and get started, it's really hard to get out. It just is. And so you have to also have a little bit of a cushion in there for whatever you have agreed to pay, and kind of expect that you're going to, it may increase, because that's more common now than anything I've seen is that increase.
Absolutely. Yes, great. Now, when it comes to, because I know I have a contract right now that came over one of my sellers, and he says to me, the agent on the buyer side says, well, we can close fast because we did get multiple offers. He said we can close fast because only thing we'll be waiting on is title.
Oh, wow. Okay.
However, we know nothing has been ran because again, I have the seller. So, tell us a
Mm-hmm.
little bit about the
process of title and everybody
title and clearances and
yeah. So as soon as we get a contract in, we have a couple of steps that we go through. And I won't bore you with a lot of the details because people, don't necessarily prefer our process of waiting, because we really want to make sure that you are invested in your deal. So two things we're looking for is earnest money, and we're also looking for due diligence. And so we will follow up with agents to say, hey, has the due diligence ended? And even if you have completed all of your inspections and you still got 3 days left on due diligence, you can tell us, hey, we finished our inspections. We're good on due diligence. That helps us to know as we start to run title, because there is a cost and an expense to it. But what we do is we run an exam on the history, which is the chain of title of the property. We're also looking for liens and judgments against the seller. And so anytime the seller has a lien or a judgment, that lien or judgment may levy against the property that that seller owns. And so we're looking for that. We're also looking at whether or not the HOA is going to clear it and say whether or not there are any HOA outstanding dues and fees or violations. We also see violations. So even though your fees may be paid, there may be a violation that's outstanding. They've asked you to clear some rubbish, or they've asked you to remove some cars from your garage or your driveway and you haven't done it. And so then they start to kind of add those fees up. And so before we can actually transfer ownership, we have to make sure that the violation is clear. So we have to get a letter from the HOA that says this violation is clear, because they'll give us the HOA letter and it'll say this homeowner has a violation. So these are some of the things that we're looking at. We've had even situations where a buyer even has had a judgment against them. So it wasn't just a seller, but a buyer has a judgment against them. They have a lender. The lender is asking us to show them not only what the seller has on title, but if we see something on the buyer's side, we have to show it to them as well. So most lenders have done a really good job and they already know it. So like if a person has an IRS lien or they have a credit card debt, maybe they've seen it in their credit report, but there are some times when they don't see it. And they will say, this got to be paid before we can close. And so they will add whatever that credit card, bill or balance is to the settlement statement, and it'll be paid. So it's a part of what the buyer has to bring for closing costs. And the reason for that is as soon as that buyer takes ownership of the property, they then become the title owner. And almost before we can even file our security deed on behalf of the lender, that lien or judgment that they got from that creditor, it attaches immediately because it's already on them. So they are trying to make sure that the lender is trying to make sure that when they extend a loan to someone, that they're in first priority position, that they're not extending a loan to someone who has an IRS lien or judgment already pending against them. They don't want to be behind them. Because it's really about the order in which things are filed. Yeah, so you would always think that a mortgage is going to be first and primary because it's a mortgage. It may be a $500,000 mortgage, but you could have a $15,000 judgment that hits before your mortgage hits, and that's in first priority at that point. We're looking, we're just looking to make sure that everybody has a clean bill of health, because our goal at closing is to make sure that when we give the buyer their new title, that it is not encumbered. There are no liens, there are no judgments. They're the only one on title. And nobody's going to come back to them and say, which is crazy because I had this happen, that, they own the property. We want to make sure that the buyer owns it. So, we're clearing all that stuff. But, this is, real estate is so unbelievable. Like, there are so many things that happen.
And people think they think it has to be such a quick process. We rather for things to be done right. Instead of this overnight, they pull title, we ready, we got money, got our money for closing, but it's really beyond that. And we do want to make sure everything is done correctly, where you got a free and clear title, because we know there's a lot of things that has happened, with different neighborhoods where they revitalizing, and then, with these titles, these taxes, because I did have a situation where I had a buyer My buyer, he's in the military. Name is very common. A very common name. And so we getting ready to close, and they say, oh, he had a lien. So I look at, I was back then looking at the sellers, of course, with the lien or whatever for the property, but didn't think of that for the buyer. And the buyer had a lien for $20,000. So it was like, okay, you got to clear this lien, but come to find out, the lien was not even him. It was another race type, but they had the same name. And it was not him at all. So he had to submit his ID and some other things. I think the other guy, he wasn't military. My guy was military. And then, of course, they were different races.
Right.
But it was clear. But I just felt like, okay, that was interesting. We delayed a few days.
And the thing about that is what we normally look at is the socials. And so as long as we can, get the creditor to give us that information, then we can, match the social against the person who is the buyer or seller that we're working for. Okay. The problem with those things come into play where there's someone else further back in the chain of title that had a lien or a judgment, or it's an estate. That happens quite a bit where a person comes into a property as the heir of a property and they don't really know what their deceased parent or grandparent or loved one had. And then we're trying to get a payoff from a creditor that they had. And if they don't have the right documentation, we can't get those payoffs and those types of things. So, having that, letters testamentary, letters of administration. And then again, like I said, if it's not an estate property where you have that and it's somebody further back in the chain of title, we had that recently where a person did a quitclaim deed. They bought the property and they were really happy about it. And then they were getting ready to do something else. And they were, faced with the idea that the person that they purchased it from someone else who had a lien. So these are like 2 or 3 people back in the chain of title, and it's not paid off. And we can't reach them. So what that means is we can't get their authorization to get a payoff from this creditor. You see what I'm saying?
Wow. Okay.
So, that really, really creates problems. And then people have to kind of go back to the person they bought it from, and then they go back to that person, and they're trying their best to find this person. And they can't call them and say, hey, can you pay this? Because they really don't have the obligation to. But at a minimum, can we at least get your authorization to find out what the debt is so that we can pay it if need be. So, it's a lot of things like that. But, yeah, we're trying to clear.
How do you feel about water bills on title? I see it a lot for the city of Atlanta. Yeah, I don't know, like some of the other counties, but
it's a real sticking point because especially with estates, but definitely sellers have these water bill situations. And to them, they've been paying it. Maybe they don't even know that the water bill situation exists. And so we have to get, and the city of Atlanta has recently changed their processes, which makes it difficult to get those water bills. But you actually have to send them in now to make a request. You have to send a paper check to them. Which creates another time issue. But we really we should not close without getting confirmation that the water bill is zero. Because again, the water bill is one of those things where if there was a person who is a record owner, someone who was in the chain of title that has this outstanding water bill, then it needs to be paid. So what you have is a situation where there are people who lived in the property. And so then the question becomes, was this person a title owner or was it just a renter? So there's different rules.
Okay.
And so if the person really did own the property at some point and then that water bill is out there, then it's got to be paid. And we've had one, you remember?
Yes.
That water bill was over $100,000.
Yes, it was over $100K. It ended up getting down to the 80s, and I think it was over a year or something.
You did that. Yeah, you did that. She worked behind the scenes for months to get that water. Maybe even a year. I feel like it was a long time, but she worked behind the scenes, pulled some strings, and was able to negotiate that water bill down. But literally, we could not close with that water bill out there until it got paid. So that's one of those things
they put their lien to, even if getting down to with the water, whose side it was on, it was a water leak, was it the city side, was it the homeowner? So, but definitely, you want to be able to make sure that's what definitely a clear title. You take ownership.
Yes.
So yes. Now, when it comes to I know we said about the title with liens. When it comes to property, what's your legal expertise, rather like estates and trusts?
Oh, okay. Well, estates, again, if you have letters testamentary, letters of administration, you are able, let me caveat that again.
Okay.
If you have letters testamentary that give you the authority to sell, or
Okay.
letters of administration that give you the authority to sell, so all of those are not the same.
Mm-hmm.
So letters testamentary is going to be based on what the will says. If the will says you can sell property, or if the will says that it's all up to the executor to do and distribute property, then they'd be able to do it based on what the will gives, that authority. If there is no will, then we have to look to what the court gives as a part of the letters of administration. Are they giving full powers to that administrator? And a lot of times, if you have families that are splintered, they may not come together. And then the court only gives a limited authority. And limited authority would just mean that, they have this administrator title, but they have to go back to the court to get the court's permission before they can sell. So, and some other things they may need to get the court's permission for. So definitely, anytime you're dealing with an estate, you got to have the right authority, and whether it comes from the court or it comes from the will, and the appointment comes from the court to actually move forward with the will. I think that's a big piece. Trusts are a little bit different, and that's one of the reasons why people are moving into trust, because trusts do not come down to court authority. The trustee gets their authority from the grantor or the settlor. So the person that creates that trust gives the authority to that person. A lot of times people create trust and they are the trustees of their own trust. So they have the authority within them. But, the authority is stated and is provided for inside of the trust. The trust is a secret document in the sense that it's not something that should become public record. So a lot of times there's no record anywhere, so to speak, that is public for people to go and see if this trustee is a valid trustee. So we really do have to rely on people to provide us documentation. Affidavits of trust or certificates of trust is what we look at to determine whether or not a person is the trustee and has that power and authority. And then, also making sure that the property is really held by the trust. So that's the other side of it. A lot of people create these big, beautiful trusts, but then they don't fund them. And so I've had clients where their parents had trust, but they didn't actually take the property that they own and put it into the trust. So when they passed away, the property was still in their parents' estate, and then they had this trust. So what they had to do as trustees was probate a will to bring everything back into the trust. And then once it's in the trust, then they can distribute it or keep it or hold it or whatever they need to do with it. But it's not always like that. So a trust is a very sophisticated document, or it can be if you utilize it that way. So if you really fund it and put in real estate or insurance policies or bank accounts, different assets into the trust, then the trust will really be able to specify how a trustee should govern and distribute.
Okay. Yes, and we'll have some more insight as well on trust, because I know I've had questions about it in the past, but yeah, we have some insight. So definitely stay tuned. Give them your information, how they can be a part and get some valuable, great legal advice.
Oh, thank you. We are easily found online. We are on Google, but we have our website at www.rsjohnsonlegal.com. We have a chat feature on our site, so you can go to the site and reach out, and one of our team members will see the information and will reach back to you. If you're specific to estate planning and you just really want to focus there, we have another website. The other website is estateplanningatournyatlanta.com. estateplanningatournyatlanta.com. Google is Wills and Probate Express. So we pretty much operate in one firm, but we do have two arms so that we reach people and they understand what they're asking for. So on the real estate side is R.S. Johnson Legal, and on the probate side is Wills and Probate Express.
Yes. And they are amazing attorneys, the whole team staff, where you're able to understand, get the legal advice, and be able to protect your properties as well, residential and commercial. Thank you for tuning in. Continue to tune in. We will be back with the part 2 of our segment. Thank you for tuning in with the R in Real Estate. Thank you to our sponsors, R.S. Johnson Legal, Real Estate Closing Firm, Will and Probate, Kelvin Pearson with State Farm Insurance, Fleeta Paul with Diamond Residential, Gerard Williams with G2L Residential and Commercial Inspections, and Abijah with AR The Brand.